got caught up in a court hearing, and so I am calling in for the first half of this. So Chewy, if you can read out the questions, then I can respond. Before we do that, let me just kind of give everyone a quick overview. There was not a lot of significant things that happened. We made some more progress on the CRP. Obviously, the judge has signed the final order. But at this point, our main focus is twofold. Number one, we are trying to get the claims resolution procedures, the CRP, in place. So we're working with Justice Trotter and the Chief Claims Administrator, Ms. Yanni. And then the other thing that we're doing is just trying to get everything from all of our clients so we can start submitting as soon as they open up the portal. Initially, they'd hoped to have the portal open July 1st. I think it's going to be delayed. They gave us a preview of what the rollout would look like, and several of us, including me, but several of the other attorneys as well, had some issues. We felt like they had put too much emphasis on certain things and then left out other important categories, and we don't want anyone to get shortchanged in this. So that was the reason why we'd sent it back and said that we thought some changes needed to be made. We heard back from them today that they are going to make those changes, but because of the size of the project, it will take some time. So we don't know if it'll be open July 1st or not. Personally, I never thought July 1st was realistic. I thought that was a bit optimistic. In my view, as long as we can get it open sometime in July, that's fine, because that will give them plenty of time to process things before the funding on August 29th. So that's kind of I'm sorry, go ahead. Okay, so that's kind of an overview of where we are. We have a number of questions that were emailed in. Chewy, if you want to read them, then I can respond, and then after that, we can open it up and take questions. Go ahead, Chewy.
Sounds good. It's first question here is, some of the funds I received from FEMA. One sec, I have somebody. Hold on. Some of the funds I received from FEMA were a grant. Will I be required to repay these funds from my settlement?
So in terms of FEMA grants, the answer is it depends. Technically, FEMA is involved in the suit, and the federal government has made a claim, so the trust could seek an offset for them. So to the extent that they know about grants that were made for specific things, then if you are making a claim for that same item, then you will not be able to recover. So in other words, if you were to say that I received $2,500 to pay for X, and then you were to ask for another $2,500 to pay for X, then that would be considered double recovery. But as long as it's not for the same thing, then you should be fine.
Thanks, Jared. Now, other question is, on my claim, can I include time spent dealing with our insurance and other fire-related issues?
Yeah, that is a very good question. The law on this is mixed. There have been some cases that have allowed this and some that have not. What we do is to take kind of a hybrid approach. So what we do is we ask our clients to let us know how much time they've spent. We call it time spent in recovery, and we list that down. And our thinking is that the trust can either do it one of two ways. They can either say we're going to pay that as an economic damage, or if not, we're going to take it into consideration and increase the amount that we would pay for the nuisance damages. And those are the annoyance, disturbance, inconvenience, mental anguish. The idea being that we want to make sure that the people that are making the decision understand just what you went through and just how onerous this was. And that's a good way of putting it into perspective. If you are able to say, you know, I spent 1,200 hours over this period of time working on it. So that's why we do that. So the answer is, technically you may not be paid for it as an economic loss, but it will be factored into your Kelly damages. Go
Okay.
ahead, Chewy.
Yeah. Are both economic and non-economic losses taxed the same?
So when it comes to taxes, I have to give you the caveat that I am not a tax attorney, I'm not a specialist, and I have no expertise in tax issues. That said, I can give you the basic general rule, and then I would encourage you to go to a CPA or a tax attorney who's knowledgeable in this. And we do have a CPA that we've recommended to clients in the past who specializes in these types of situations. So many of our clients have found him to be very helpful. But that said, you can go to your normal tax preparer and they should know the answer. So the general rule is this: if you are paid money to compensate you for a loss to real or personal property, and those would be economic losses, and you actually replace the item, then there is no taxable event because you haven't gained anything. You've just received money to compensate you for a loss, and you've replaced the item. There's no taxable event, so you shouldn't be taxed. Now, there's a million caveats to that. The most obvious one is that if you were to take a capital loss for example, damage to your home, then if you receive money to compensate you for that damage, now you've got a capital gain. So that's just something to think about and something to tell your tax preparer. In terms of non-economic damages, the general rule is that if you're being compensated for any type of non-economic damage that is associated with physical injury, then it's not taxable. But again, there are a lot of permutations here, and it can get very, very esoteric. So I strongly recommend that you talk with a qualified CPA.
Thanks, Jerry. And this is somewhat of a follow-up regarding attorney fees. Natesh, can you review how attorney fees are paid? Are attorney fees on economic loss paid by client, and attorney fees on the recovery for non-economic losses paid by PG&E? And the client provides an example.
No. Yeah, so it's actually the other way around. So the way that it works is this. As part of your damages for inverse condemnation, and that includes any kind of damage to real or personal property. So loss to your home, damage to your landscape, if you're a renter or if you're a homeowner, loss of your personal possessions, anything like that. Those damages are recoverable in inverse condemnation. So because of that, there is a fee shifting provision which requires the defendant to pay the reasonable economic costs, including attorney fees, for obtaining those. So what that means in practice is that when we submit our damages, we'll submit economic losses to include all of those things. Then what the trust is going to do, because the trust is standing in the shoes of the defendant, is to figure out what your economic losses are, apply the reasonable attorney fees and the litigation costs on top of that. On top of that, put in the non-economic damages. And the non-economic damages are separate. They're not recoverable in inverse condemnation, so they do not have to put in anything for attorney fees on that. So to give you an example, if it was $1 million in economic losses, then the trust would pay the attorney fees on that. So assuming that's $333,000, they'd put that on top of it. If you have cost of litigation, which you will, it'll go on top of that, and then they'll put something on top of that for the non-economic losses. Let's say another $250,000. So the total award would be something in the neighborhood of 1.6 million, something like that. That's kind of a rough way of looking at it. Obviously, it's different in every case, but that kind of gives you an idea of how that is factored in.
Then a follow up to that. So that means from the 1.6 million you mentioned, the, let's say, 1/3 attorney's fees would be deducted from that total amount?
Right, right. So the way that it would work is that you would, at the end of the day, you're receiving all of your economic losses, and then on top of that, you're receiving something for having gone through it. And how much that is depends upon a number of factors, including your proximity to the fire, whether you completely lost your home, all different kinds of factors.
Right. Here it says, I provided all of my information to your office. What is the next step?
Okay, well, first of all, thank you for doing that. We appreciate it. Now that we have all your information, the only thing remaining, if this hasn't been done, is to get your narrative. If that has been done, then we're completely set. We've got all the information that we need from you, and we will submit your claim as soon as the portal opens. If we have not gotten your narrative, then that's the last step. We'll get that done, and then once that is done and the portal opens, your claim will be submitted.
Thanks, Jerry. I have here a question about our consultants, our experts. It says, one of Singleton Law Firm's experts contacted us to see if we have damage such as erosion. Will we be responsible for her fees?
Now, when you say the question is, would the client be responsible for the expert's fees? If there is erosion damage and the hydrologist does a report, then obviously she charges for that report. We will advance the costs and then will be reimbursed out of the ultimate recovery. But that's what we mean when we say litigation costs. So your costs that have to be paid by the trust under inverse include not only the attorney fees, but also the litigation costs, which include expert reports.
Okay, and I just received an email and it says, please explain how the trustee will value our claims in regards to the cost of rebuilding over what was paid by insurance, including larger homes than pre-fire.
You cut out there for a second. Was the last question, or the last part of that question, including if you built a larger home than was destroyed by the fire?
Correct.
Okay. So what the trust has to do, because again, the trust is standing in the shoes of PG&E, and what PG&E would have to do is to put you back in the same type of home, so the same condition and quality as you were in prior to the fire. So let's say you had a 2,000 square foot house prior to the fire. If that house was destroyed and in rebuilding you decided to add on and you built a 22, 23, 2,400 square foot house, that's fine. You have every right to do that. However, the trust is only required to pay the cost to rebuild the 2,000 square foot home that you had. And because most of our clients, I would say probably 90% or even more of those who rebuild, build a different house. Many times it's not substantially different, but you know, if you had a house that was built in the 60s or 70s or 80s, you may want to update it. You know, you may want to put in another bathroom. You may want to do this. You may want to do that. All that is fine. However, the reason that we don't generally use the actual cost to rebuild, but instead we'll have an expert who will give us his or her estimate as to the cost to rebuild the home you lost, is because the legal standard is they have to pay the cost for the home you lost. So if you lost a home that would cost $700,000 to rebuild and you rebuilt a home for $800,000, then the trust would be responsible for paying the $700,000. And obviously, if you had no insurance, they would pay the full $700,000. If you had $600,000 in insurance, they would pay 100,000. But that's how that works. The reason that we have those individualized expert workups is because we want to make sure that our clients are compensated for the loss of the home they had. And the concern that I have about just using a generalized number, which some people do, is that it oftentimes doesn't take into account what's necessary to rebuild the specific home. So that's the answer to that.
Thanks, Jerry. Another question, can you explain how the trustee will value or put a number on emotional distress claims?
Sure. So emotional distress is figured out by taking a couple of different things into account. And there are really three categories, but let me focus on the first two initially. So the first thing that the trustee is going to look at is what we refer to as the zone of danger. And that means how close were you to the fire? And, you know, unfortunately, particularly in fires like the Camp Fire or the Redwood Valley Fire or certain areas in the Tubbs Fire, people were extraordinarily close. I mean, we have stories of people, you know, having to flee naked in the middle of the night because their home's on fire. I mean, just all kinds of harrowing experiences. So that's why we use a narrative. And what the trustee is going to look at is how close you were to the fire and how long it took you to get out of that zone of danger. So if you were someone who received notice well in advance and you were able to get out early, then obviously you're going to get less than someone who, to use an extreme example, was awakened with their house on fire and just had to flee in the middle of the night and is running down the street naked. You know, if you're somebody who was caught on the Skyway and you're sitting there terrified, understandably for your life, you're going to recover more than the person who may have been at work or may have been out of town when it happened. They're just going to look at the circumstances and make that determination. So that's category number one, the zone of danger, emotional distress. The second category is what are called nuisance damages. And I know it's a lot more than a nuisance, but that's just the cause of action. That's the name of the cause of action. So they're referred to shorthand as nuisance damages. And those are to compensate you for the annoyance, disturbance, inconvenience, and mental anguish that you have experienced as a result of the damage to your property. So this is where the fact that you had your home burned down and your life is put on hold for 2 years or even longer, the fact that you had to spend hundreds, if not 1,000 hours dealing with the insurance company, all of these things are factors that go into those nuisance damages, and that is something that they're going to consider. The final, the other thing that I should say, and this is very important, the other thing that they're considering there is how your life changed. Obviously, some people were in a more fortunate circumstance than others. You know, some of our clients were able to get into a new home, whether it was a rental or whether they used their ALE to purchase a home right away. And that's obviously very different than someone who had to move several different times, who was in an apartment with, you know, a family of 5 in a 1 or a 2 bedroom apartment, or even in the extreme cases, someone who was homeless. And, you know, we've had that, unfortunately. So they look at, again, what you went through to include how your life changed after the fire. So those are important factors to put in. And then the final category that is considered under emotional distress / non-economic damages are cherished possessions. And these would be the items you have that don't have any fair market value, but which have tremendous sentimental value to you. And you know, the classic example I give is I have a photograph of my grandmother who passed away recently, and we were very close. And that's something that obviously doesn't have a fair market value. No one's going to pay for that, but it certainly means a tremendous amount to me. It's irreplaceable. And it's, you know, it's something that means a lot. I mean, frankly, after my kids and my dogs, it's probably the first thing I'd grab if my house was on fire. So that kind of gives you an example, because you can replace all the other stuff. You can't replace that. And everyone has those, whether they're photographs of deceased loved ones, whether they're pictures of your children when they were young, whether it's something your kids made for you in kindergarten, Father's Day, Mother's Day cards, all those kinds of things. So, what we ask our clients to do is just list out some significant things like that. And this can be a lot of other things too. For example, one thing that comes up not infrequently, unfortunately, are people who've had family members serve in the military who've passed away and who received the flag from their coffin. Something like that. I mean, again, that's not something that has a fair market value, but it's obviously incredibly important to you. So those are the kind of things, and those three categories are what they're going to look at when they come up with an emotional distress non-economic damage number. Again, this is a lot more art than science. Unfortunately, unlike the cost to rebuild a home, we can't get an expert to come in and give us his or her opinion. So what they do is they look at the narrative, and then they're going to look at prior awards in these cases and try and come up with a fair number based on that. But again, it's a lot more art than science, and it's a very difficult thing to quantify.
Thanks, Jared. And one more submission here I have is, can lost wages and use of vacation/PTO also be part of my claim?
They can. Now, in reference to the earlier question, someone had asked about how are things taxed. One thing that you do want to keep in mind is that any lost income that you receive, because you would have to pay taxes on it, that is something that you would have to pay taxes on. So that's in a different category. But yes, you can recover. How much you can recover depends upon the nature of the damages. There is something called the economic loss rule, which limits how much you can recover if it's purely economic. And to give you an example, we had a client in a prior fire who lived in a very small town. He was the only real estate agent in that town. And although his office was not damaged, the majority of the town was. And so as a result, he lost a lot of his income. However, he was not able to recover that because he didn't suffer the damage to his property, and it wasn't a result of the damage to his property. So, that can get, again, pretty esoteric. So if you have any questions about whether or not you would qualify for the loss of wages or having to take vacation time, just let us know and we can evaluate it and give you our thoughts.
Thank you, Jerry. A question here is just submitted via chat. Can you explain the judicial review process? Should we have filed an objection? Appears 3 people filed and now have a second venue to seek second party review if claims are denied.
Right. No, that's a really good question. My answer to that is no. All of us did not file those, and there was a reason for that. And by all of us, I mean myself and all of the other attorneys who represent claimants in this action. You are correct. There are 3 individuals who did. This is, I want to choose my words carefully here because obviously they are fire victims, and I don't want to denigrate them, but I strongly believe that what they did was not the right thing. One of the things that we recognized when we had this case and we were placed into bankruptcy, and so we were trying to come up with something that was fair to everyone, is that this, in order to work, was only going to work if the same rules applied to everybody. So we all made agreements among ourselves not to go outside that and try and get anything for our clients that wasn't available to everyone. In other words, we obviously would fight as hard as possible for our clients and make sure that our clients received the most they possibly could. but we wouldn't try and change the rules for our clients. And again, to their credit, every single plaintiff's attorney followed through on this, and this agreement worked. However, there were a couple of people, one of whom represents Baupost, which, if you've been following this litigation, there's been a lot of, shall we say, harsh feelings about the fact that a certain hedge fund is very involved in pretty much all sides of it. They owned equity, they owned subrogation claims, and they ended up making a ton of money. Well, there was a fire victim who represents Baupost. She represented herself as part of the litigation, and she did not comply with this agreement that we all had. And so she's one of the people, and then I think her neighbors were the other ones that did it, and they went ahead and filed that. And so what it means, it doesn't have any major impact, but what it means is that once they go through the whole process, if they're not satisfied, then they can go to court. And it does mean that their case will take a lot longer. But the reason that we all agreed not to do it is that there was simply no way that we could get this done in any reasonable period of time if we went that route. What the trustee told us when we were talking about whether or not to include a right to go to court after you'd exhausted all your appeals in the procedure is, he basically said, look, if you guys want to do this, which you can, what that's going to mean from a payout perspective, because the trustee has a fiduciary duty to all the plaintiffs and he has to make sure that everyone is treated fairly, is that the payments will not begin until everyone's case is resolved. So right now what's going to happen is everyone submits, and then once their materials go in, the trustee will make an evaluation. If they're happy with it, then you receive the initial payment, which again would probably be around 75%. But what he said is, if we put in this right to go to court, in order for the trustee to be able to budget properly, he'll have to wait until all 77,000 claims are resolved before he makes any payments, which likely would be years, particularly if people are going to go to court. So that was why we made the decision we did. Again, there's only these 3 people that didn't abide by it. And, again, I wish they had, but, they had the right not to, and they elected not to.
Thank you, Jerry. Question here is, do clients have the, will clients be able to ask for stocks as payment for settlement?
Okay, so I want to make sure I heard that correctly. Can clients ask for stock? That was the question?
Yes.
No. This was something that we looked at initially, and there were people that wanted to do it both ways. Ultimately, the trustee decided that it would not make sense to have individuals get paid in stock. So the trustee is going to be the one that owns the stock, and then the trust will sell it, or rather the trust is the one that owns the stock, and the trust will sell it as necessary to pay the awards.
Thank you, Jerry. I have a question here, live question from Mr. Harris.
Sure.
Hey, yeah, hi. I know I've asked a couple questions because we've already built and sold the house and did that, and we spoke last week. And
Right.
I received 3 weeks ago a DIV report from Doreen Zimmerman, and I guess it says at the top for mediation use only. Anyways, she came up with the value of our home pre-fire, and then post-fire, or post-fire with the land, and then what the value range would be. And obviously I disagree with those values right there. So I said that to you, you wrote some stuff down, and then nobody's called me, but a Janice, who's a real estate agent, called me. and walked me through my property the other day, going through it and coming up with a value. And she did, and she's emailed me that value. So I'm kind of at a loss from this DIV to what that is, because nobody's called me and explained to me that that was even going to happen. So I understand probably why they're happening, but what is my situation right now with those things?
Right. So I certainly remember when we talked. And so what I asked my team to do, because your case is kind of unique. And so what I asked the team to do was to come up with estimates doing it both ways, both the DIV and using the cost of cure to see which one is going to be more advantageous, and see if we can, because you did actually rebuild before you sold, put in the cost of cure. So that's what we're in the process of doing right now. And I'm hoping that we'll have some more information in the next couple of weeks. Then we can sit down with you, talk about what the options are. And if the numbers still aren't to your satisfaction, then let's see what else we can do. Sometimes it's worth it to get another DIV report, because, you know, everybody makes mistakes. And if it turns out that the initial report is inaccurate, then we want to make changes.
Well, I mean, I'll try to be short here. So the second one from the Janice they called, that value there is real close to what she came up to what we sold it for. So isn't that kind of self-explanatory of what the value post-fire it would be?
Yeah, except that the thing with the DIV is that it's not what you sell the property for, it's the day after the fire, which is what we want to use, because we want that DIV to be as high as possible. So in other words, what we're trying to do is to get a high, obviously within reason, a high pre-fire value and then a low post-fire value, so the gap between them, the diminution in value, is as big as possible.
Well, and that's what she did. The second, Janice called that her appraisal on it after going through it was pre-fire of what our house was before.
I see.
That's what he valued it at, and we're happy with that value. That value is close to what after we rebuilt it, we sold it. So
I understand.
But it's way higher than the DIV report.
Then what we need to do is, and first of all, I don't want to rule out cost of cure, because it's a unique situation where you rebuild your home. So I think what we want to do is let's get that final cost of cure in, see if that's higher than either the DIV or the real estate one. If it's not, then we can either use what the realtor came up with, or if it turns out that the trust is going to require that an MAI appraiser do it, then we can work with the appraiser to take into account the factors that the realtor used. So that's what I would recommend.
Okay, good. And you have everything else of ours. We've already done our story when she's called us and everything. So our whole case to be solidified and sealed is based on what we just spoke about.
Got it. And like I said, it's going to be at least, I think 2 weeks, probably more like a month before the portal is up and running. So we've got a little bit of time. Okay. But again, yours is a more unique one. So we want to make sure we get this right.
Okay, cool.
Yeah.
Thank you.
No problem. All right, Chewy, who's next?
I have a question here about when will we know what the value of our claim that you are submitting is?
Well, it won't be until we submit, because that's when we have all the information. So typically what we do is most of our clients just, they'll say, go ahead and submit when it's ready. But some of our clients want to see everything before, and that's fine. You have absolutely every right to do that. You just need to let us know. So if you're someone who wants to review everything before it goes in, please let us know. We'll make sure that gets into your file, and that way you can review things before they're submitted.
Okay, I just had an email here regarding recovering on behalf of deceased family members. Are we able to do that? If so, how?
The answer is yes. So the most extreme case is if you have someone if you have a relative who perished in the fire, and obviously, unfortunately, there were a large number in all of the fires involved in this together. There were at least 130. and I think there'll probably be another 30 to 40 at least once the delayed claims come in. So you can absolutely recover for that. Now, if you're talking about someone who did not perish as a result of the fire, but let's say died of natural causes, a year after the fire or something like that, and they had a claim, then what happens is the probate code governs who the next in line is. If there's a will, then they have the right to pursue it. If there's not a will and the person died intestate, then the probate code indicates who has to bring that claim on the decedent's behalf. And under California law, you can recover any economic damages that the decedent would have been entitled to recover. Unfortunately, any non-economic damages, so the emotional distress that the decedent went through, unfortunately does die with them, but the economic damages, so the damages to real or personal property, anything like that, those survive, and the heir can bring them.
Okay, I'm scrolling through these. I don't have any more questions here via email or the chat. So if anybody has a question they want to ask, they can unmute themselves and ask Jerry your question.
Well, I'm Phyllis Bremer, and I do have a question. Can you hear me?
Yes, I can, please.
Okay. So if we have $13.5 billion in this settlement, and it includes 77,000 claims, and it's not all equal, we could be looking at, a minimal amount of compensation for the loss of what we have. I mean, I don't have any family members that died, have a lifestyle, we're in our 70s, have animals that perished, treasured possessions. My dad's flag, as you mentioned, my mom's remains that was in my house. So, I mean, how can that isn't, if you take just the value of the 13.5 and divide it by the 77, thousand claims you have, it's like, it's what? It's just like nothing. It's like,
well,
what is you been doing this for?
Sure. Well, here's what I think is going to happen based upon the information we have in the prior cases. Remember that the claims are by no means equal, and there is a large percentage that is going to be very low. There's probably 25% or so of all claims that consist of smoke and ash damage to the home and evacuation. And, while I don't want to minimize that, I mean, that does cost money to repair, and evacuation is certainly difficult. Those claims are going to be much smaller. And so you're going to see a significant number of people whose claims are going to be 10, 20,000. And then on the flip side, you're going to see people whose claims are much higher. Typically, an uninsured or an insured homeowner has about $100,000 to $300,000 of uninsured damage to their property. That's kind of the rule of thumb. For some people, it's a lot higher. For some people, it's a lot lower. So the typical, value of most cases is somewhere around 500,000 to 600,000. It can be a little more, but that's usually where it is, and that's per property. And so if you do it on that basis and you do the math, then it works out to be pretty much in line with what prior cases have settled for. And by the prior cases, we're looking at the thousands of cases that settled in the SDG&E 2007 fires, the Butte fire, Powerhouse, all of these other fires. So I certainly understand the concern, but I think it's critical to remember that of those claims, the 77,000, there are 24,000 addresses. And of those 24,000, about 6,000 or more are going to be smoke and soot. So when you figure that those cases are worth on average about $30,000 for the whole property, now you can see how it goes up significantly. And I think the average case is probably going to be worth, 500,000, maybe a little bit more. And, you know, it may not be what you'd get if you go to trial. In fact, I'm sure it wouldn't be. But in terms of the settlement value of these cases, the numbers we have indicate that it's going to be in line with what prior cases' average settlement numbers have been.
Okay, I have another one in case anybody's interested.
Yeah.
We have been displaced. We have purchased a home in Arizona because there's just no place to live in our community. Our home was worth, they said, $320, which was silly. They paid us out at $515 to purchase this home. We still want to rebuild up there. We're still confused as to what the value, whether we should go back to our insurance company or if this should be part of the claim, if we should have a conversation with you or conversation with the insurance company. It's only been a year and a half. That's a short time to make a decision of what the rest of your life is going to be. You know, I mean,
Sure. Yeah, so you absolutely can seek the cost of cure, you know, the cost to rebuild. If you have not maxed out your insurance, then you definitely want to do that. So if there's available amounts on your policy, then you can talk to our insurance expert about how you can potentially get those. But in terms of what you can seek in the lawsuit, if you're asking to recover the cost to rebuild your home, then you can absolutely make that the measure of damages. Obviously, the amount you've received in insurance will be deducted from that. So if it would cost you $750,000 to rebuild, but you received 500, I think you said 515 in
yes.
insurance, then you would deduct that 515 from the 750, and that would be the real property damages.
And at what point would I have to prove or disprove or get building permits? That's what we're struggling with. Is we're still new. This is still very raw. I don't know.
Yeah.
Maybe somebody's moved on, but we get up every morning wanting to go to our back porch and have our coffee and watch our deer. And so it's been real difficult for us to move on to even get building permits or start that process. How does that factor in?
Well, you don't have to get building permits or anything like that. There are some cases where the other side is going to say, or in this case, the trust, we would like to see some evidence that the person intends to. And that evidence can be, if you have it, building permits, architectural drawings, anything like that. Or it can just be, look, we've been struggling. We're now in a position where we want to do this, but we need the money to get started. So, you know, we can sign a declaration saying we want to rebuild, and that should be sufficient.
Okay. Thank you. That was very clear. Thank you.
Sure.
Appreciate that.
Gary, I have an email that was just submitted. The question is, what is the date that current fire victims will no longer take a bagged seat if PG&E starts another catastrophe tomorrow? Is that date June 20th?
Okay. So, yeah, it has to be after June 30th. Or if they officially emerge. My understanding is the judge is going to sign the final order. He signed the preliminary order, but the final order is coming early next week. Once that happens, then the requirements of AB 1054 are met. And once the requirements of AB 1054 are met, then if any future fire, you know, God forbid, a major disaster occurs, then the new victims would go after PG&E in Superior Court and would be able to recover from, number one, PG&E's insurance, and then number two, AB 1054, if the damages exceeds the $1 billion in insurance.
Thank you, Jerry. Another question just submitted is, we had to take out loans to pay the difference between insurance payout and building costs. Mm-hmm. Is that interest recoverable in our claims?
It's a good question. It's technically the answer generally is no, but it's definitely worth submitting because you never know how they're going to view it. So anytime you have something like that, my general view is you submit it, you say, look, this is something I incurred as a result of the fire, and you put the onus on them. If they decide that it's recoverable, great. If they don't, they tend to make it up in some other way. I mean, what I always believe in is always submit all legitimate damages, because the law is a little funny in terms of there are some things it just doesn't allow you to recover for. But that said, if the claims administrator or the trustee looks at it and says, this is legitimate, I can't award it under this, subconsciously or consciously, they may make it up in another area, whether that's emotional distress or Kelly or whatever. So I always say, when you've got something like that, submit it, see what happens.
Thank you, Jerry. I don't have any more questions via email or chat.
All right. Does anybody have any questions who is on Zoom?
I have a question.
Please.
Somebody. Hello?
Yes.
So you mentioned earlier in the town hall that you had discussed what was going to be on the claims restitution procedures, and that there were some differences in terms of what some of the attorneys thought should be emphasized or de-emphasized versus what they had come up with.
Right.
Is that correct?
Yes.
Would you be able to illuminate a little bit what they had undervalued and what you think they should have valued more, and vice versa?
Sure. No, it wasn't so much the undervaluing versus overvaluing. It was more what the focus was on. And so one of the main concerns that we had is that we basically didn't want to, for example, in emotional distress, the inclination behind the folks who were drafting it was basically to come up with a checklist and say, did you have X, Y, Z? And what all of us who've done these cases before said is, the problem is if you do that, it's kind of like giving a test and giving the answers, because a lot of people are going to look at it and just say, okay, and check all the boxes. So the better way to do it is to have a narrative and ask everyone to let the trustee and the claims administrator know what they experienced. And that way, the claims administrator and trustee know what they're looking for, but it doesn't, kind of signal to the person, here's what you should check. So that's kind of one example. There were some other concerns in terms of just, various interests, like were they going to allow nuisance damages on commercial properties, things like that. So there just were a lot of issues that we felt needed to be ironed out. And so we didn't believe it was in its final format. They are working very hard, and I think overall they're doing a good job, but I just don't think it's quite ready yet. And the thought that we all had and that they've agreed with is we don't want to roll it out early just to meet an arbitrary deadline. We want to make sure that we get it done perfectly. So that's what we're working on.
And I have another question also.
Sure.
I'm a little unclear, partly because of when you say on top of when you're talking about the claim. So let's say, just hypothetically, somebody has $1 million. That's the submission that you give to the trustee.
Mm-hmm.
Well, let's say they agree with it, just for the sake of argument.
Sure.
So your attorney fees would then be $333,000.
Right.
And you said that goes on top of. So I'm not clear whether the 333 is taken out of the $1 million, or whether the trust provides both the $1 million and the 333.
Yeah, the trust provides both.
Okay. And will we be receiving some documentation about the experts we've used, how much they cost, and so we'll know what's going to be deducted off the top?
Yes. Yeah, the way that it works is we have obviously a file for each person, and that's something that we keep. So when we do the accounting with our client, before anything is finalized in terms of, you know, getting the check and doing that kind of stuff, you'll get what we refer to as a distribution worksheet, and it lays out the total amount, what the costs and fees are, and you know, you have the opportunity to look at that. If you think something's wrong or you think something's unreasonable, you are absolutely entitled to challenge it. Once you're satisfied with everything, it will also say your net amount. You sign it, and then you get your check.
Thank you.
Hello, Jerry.
Yes.
Okay. A question was brought to me in regards to if one of the victims, say it's a married couple and both of them are on Social Security disability, and the trustee, the claim submitted is paid in full, and call it a couple $100,000. The impact to the Social Security payments that those people are receiving, are those going to be impacted as additional income, and then Social Security cuts back on the payments?
Yeah, that's a good question. So the thing about the different programs that people receive, and it can be a lot of things. It can be Social Security, it can be TANF, you know, you name it. There's just a million. Medi-Cal, Medicare, just a lot of different things out there. So what I always tell people is, if you are receiving a program, and if you are concerned that you may become ineligible, let us know early on. And there are experts that we can refer you to who can let you know. Because we've had this come up before, and there are ways to structure the payment such that, for example, if you're on Medi-Cal, you don't lose eligibility. In other words, if you lost your home, but you were receiving Medi-Cal because you were disabled, or if you were receiving disability, if you just receive a check for the entire amount and it's still in your account, I believe it's 30 days, for more than 30 days, then all of a sudden you lose eligibility. Even though your circumstances haven't changed, the reason you got the money is so that you could, you know, buy another home. So that's something that we can address, and we can structure it in such a way that you can replace the items you lost, but still maintain eligibility. However, it does require, you definitely have to have a plan in place to do it. So if you're concerned about that, or if you know anybody who's concerned about it, please let us know and we can work with them.
Thank you.
Jerry, I have a question.
Sure.
It's my understanding that we will submit our claim in the near future, and it will include, of course, you know, the difference between the cost of building versus the insurance compensation, and it may include loss of income, et cetera, et cetera. And it's my understanding that we will then go to the trustee, and that person will say, okay, give us an amount, and we may or may not accept that. And if we don't accept it, we will go into arbitration, I believe. Could you give us, if that's correct?
I was going to say first mediation and then arbitration. Yes.
Okay. So could you give us an understanding of what the timeline for those for that might be?
Yeah, it'll be case by case, because, for example, it may be that in a specific case, let's use your case for example. Maybe that in your case, the reason that we were not happy with the award that was given is that the trustee didn't place what we felt was sufficient value on a particular item. Let's say it's trees. And so what we may want to do is to get another report to address a specific issue. If that happens, then it's going to take longer. If that doesn't happen, and it's just a situation where, you know, both sides looked at it and there just wasn't a meeting of the minds, which happens sometimes, then it should be pretty quick. There's not going to be a hard and fast, but the general idea is that we want it to happen within 30 days because we don't want these things to drag on. Once you're in, we want to make sure that you get processed and get your claim through. And that benefits everybody because when a claims administrator looks at it and reviews it, it makes sense that they go through it while it's fresh in their mind rather than having them have to spend more time and get back up to speed on it. We want to, once you get in, we want to get your case resolved as quickly as possible.
I think previously you said that mediation might occur by October. Is that correct?
The first payments might occur by October. So what the trustee said when we spoke last week is that at this point, they're anticipating the initial payments happening in October. And there's nothing that's happened so far that's led us to believe that won't be the case.
So mediation then is completed by, before payment, right?
Well, it depends. Remember, what'll happen is we'll submit everything and then they will give you a written offer. And it may be that it's satisfactory to you, in which case you don't have to do anything else. You just sign it, accept it, and then you get your check. On the other hand, you may not agree with it. In that case, then you would go to mediation. But in terms of when initial offers will come out, I'm thinking it's going to be sometime in September, because I think what will happen is the funding is on August 29th. Then they're going to have a number of claims processed. So they'll issue the initial offers in September. Then they're going to wait. And if people accept them, then they will cut the checks, and usually it takes about 30 days. So that's why it would be October before they would be received. If people say, and I'm sure some people in the initial batch will say no, then they would go forward with mediation, and that should happen within 30 days. So my guess would be sometime in September or October.
Okay, that timeline is important, so thank you very much.
Of course.
Jerry, I do have a question here. Is the CRP finalized?
No, that's what we're working on now. And we got the initial, I'll call it the initial final version, and we felt there were still some things that needed to be worked on. So had a very productive meeting. Changes are being made. We're hoping to get new procedures by next week, but it is an ongoing process. So it wouldn't surprise me if it takes a couple of more weeks.
Thank you. In regard to the follow-up regarding mediation, is there additional attorney's fees if we do end up in mediation?
No, not at all.
That is it as far as the submissions here, Jerry.
Okay, how about on the big board? Do we have any questions? I have just a brief question.
Sure.
I don't know how bright it is. I'm trying to picture being the claims people that are handling this as these are coming in. And if I'm on the top of the stack, if I'm at the beginning, are they trying to parlay that money to make sure it stretches out through all these claims, and they're going to be a little tighter then, and they're compared to being at the end where there's going to be a lot more money or less money or whatever? What is the formula that dictates that? I mean, you have to be a little bit discreet on the first claims, correct?
Well, I don't think so, and here's why. They're not going to pay 100% of the claims initially.
Okay.
And so that's why I don't believe there's going to be a significant difference. What they're going to do is to issue those initial awards and then pay a percentage. Again, right now we're using 75%, could be more, could be less, but they're going to pay 75% and they're going to hold back 25%, which, when you're talking about 13.5 billion is a lot of money. And so if it turns out that after everybody's gone through, there's no way to pay everybody 100 cents of their award, and there's only enough to pay everybody 90, then they'll do it on a pro rata basis. So whether you're first or last, you're still going to receive 90% of what your award was.
Okay, I understand that. So a good formula, not counting costs, is take 33% off 13.5 million, and that's the money they're working with, not counting costs, correct? That's pretty much what's going to be
yeah.
distributed. Roughly a little bit under 9 million or whatever it would be. 9 billion, sorry.
Yeah.
It's kind of what's going out minus not counting costs.
Right. And now, again, there's also, when you say going out, it all goes out to the client, but after you get rid of attorney fees, it'll be something like that. Again, now that's assuming that we don't get more money from the third-party suits. And we've talked about those before, but we're very optimistic that we're going to get at least a couple $100 million and hopefully more from those suits. So that obviously will go into the trust as well. Okay. Also, there's going to be interest on the money, which is going to be significant given how much it is. Now that is going to be used to pay claims expenses. We think the interest is going to be eaten up by those claims expenses. The other possibility, and this is something we're really hoping for, is that the stock is going to appreciate. If some of the experts are right and that stock is worth 14 to 14.5, I'm sorry, that stock is worth more, then the total amount would be 14 to 14.5 once all is said and done. So yeah, that you're right. The rough is about a third off, but the 13.5 hopefully is going to be a little more.
Going to go up. Okay.
Yeah.
All right. Thank you.
Sure. Okay. What else?
Jerry, can fire victims recover the increased cost of fire insurance?
Hello?
Yes. Yeah, absolutely. If you are somebody who had your, some people get canceled, and so they have to get new policies. And if you did, and it's more, that qualifies. Or if you had, say, Farmers, and Farmers has increased your policy premiums, absolutely. You are absolutely entitled to recover that. Typically, we go out at least 3 years because that's the cycle. But, just let us know and we can put it in.
Thank you, Jerry. When will you know what percentage is going to be held back?
That will be when they issue the final claims resolution procedures. So again, I'm hopeful that'll be done within a couple of weeks. But as soon as I know, I'll let everybody know.
Thank you.
Okay, who's next?
I believe that was our last question, Jerry.
Okay. Well, does anybody have anything else they want to ask?
Hello?
Yes. All right. We got somebody. Go ahead.
Yes. How are you?
Good. How are you doing?
Not so bad. I'm going back to a question that you said, the healthcare, that both my son's health and mine has deteriorated since the fire. My esophagus was burnt, and I'm going to get treatment on tomorrow to actually confirm it was from the fire. And my son, he is obese now, and he has to get gastric surgery. I was wondering how that works. I mean, because
okay, no, it's a good question.
A year. You said it would be a year, then they don't cover after that. But
there's no cutoff. What we have to do is this: personal injury claims have to be more precise than other claims, for obvious reasons. I mean, if your house burns down, not a lot of dispute about what causes that. But for personal injury claims, depending upon what it was, there can be a great deal of dispute as to whether or not the fire is a substantial factor. So what we do is this: if you believe you have a personal injury claim, then please let us know. And what we will do is order the medical records, and then we'll have a physician give an opinion. And what the physician has to say in order for it to qualify is that, in their opinion, to a reasonable medical certainty, the fire was a substantial factor in causing whatever the injury is. I think you said problems with your esophagus, which is normal. Certainly a lot of people have had problems with their respiratory system as a result of the smoke inhalation. So again, I really encourage you, please let the office know. Brody McBride is the partner at the office who is in
Okay.
charge of overseeing all personal injury. But if you just call the office tomorrow, then they can put you in touch with the right people.
Okay, and I have one more question.
Sure.
Like my son, when we moved, we couldn't find a place with substantial internet so he could work. And how long can he recover his loss of pay?
You know, it depends on the circumstances. We should probably drill down on that and get a lot more detail. So that's another thing. Just let us know. We can look at the specific facts and see what's reasonable.
All righty. Thank you, Jerry. Thank you for your help.
Sure, no problem at all.
Tomorrow.
Jerry, I have, I believe Rihanna has a question.
Go ahead. Rihanna, are you on the phone? Chewy, I'm not hearing anything. Are you?
No, I do have a question submitted just now via email.
Okay, go ahead.
Does a hydrology report cover erosion for the fire and post-fire related activities?
Yes, that's just our shorthand. Technically, she's an engineer with a specialty in, it's long, I can't even remember what it is. We just call her a hydrologist. But yes, she is a professional engineer. Her specialty is watersheds and how water relates to land and any erosion, subsidence, anything like that. So she will do a report, and that will cover not just damages immediately, but also, and this is how it usually happens, damages over the years. Typically, it will take 5 to 7 years before watersheds repair following an event like a fire. And during that time, depending upon the topography and where you live, erosion damages can be substantial. So this is unfortunately a damage we see quite a bit.
Thank you, Jerry. I believe Rihanna's question that was submitted is, do I have to rebuild on the same site?
Okay, well, that's a good question. It depends on what you mean when you say, do you have to rebuild on the same site? For insurance, it depends on your policy. Some will allow you to rebuild in another area, just like they'll allow you to buy in another area. If you're talking about the cost of cure, if you want to obtain the cost to cure, the cost to rebuild, then technically, unfortunately, it does have to be on that particular site. You could still get diminution in value if you sold the property, but if you want to recover the cost of cure to rebuild the home you had, it has to be on the site where the damage occurred.
Thank you.
All right, do we have any other questions? Okay, well, let's plan on doing this again next Thursday. If I have any updates on the CRP, I will absolutely let you know. If not, we can just answer general questions. And again, please get your information in. I know everybody's going through a lot, and we certainly don't want to put any pressure on anybody. But again, the sooner you get it in, the sooner we can get your claim submitted. So thank you all, and please don't hesitate to call us or email us if you have any questions. Take care.